Hi guys, and thank you so much for joining me. Wow, it's been a while since I've been in front of the camera. I think that the last time when I recorded a video was in October and we are now at the end of December. I hope you guys had a wonderful Christmas. If you are new here, I'm Kat and I like to talk about true crime, conspiracies and all sorts of related things. I am making this video as you have asked me in the comments of my Takoda Collins case coverage video what happened to Takoda's older brother. If you are not familiar with Takoda Collins' tragic murder, I made an entire video covering his case. The link will be in the description below if you haven't seen it yet. Before we get started, I just want to give you a quick disclaimer. All the information that I'm giving you in today's video is already found in the public domain alongside my opinions. Thank you so much. To begin with, I am just going to give you a quick summary of Takoda Collins' case and then we can talk about Takoda's older brother and the infuriating wrongful death settlement that Takoda's family received. On December 18th of 2008, just a few days before Christmas, Takoda Collins is born to Robin Collins and Al Mutahan McLean in Wisconsin, US. Takoda Collins was a bright and smart 10-year-old boy, exceptionally intelligent. He loved reading and he was truly creative. He loved to dance and rap. In rare photos of Takoda, you see a genuinely happy boy enjoying life. You wouldn't imagine in a million years the hell he went through in his short life at the hands of his own father, one who should have been a fatherly figure, one who should have protected him, reassured him when he had nightmares, telling him there are no monsters, yet his dad was the monster in his room and Takoda's nightmares were his every living hours of every single day and night. When Takoda was almost 1 year old, on November the 12th, 2009, his mother, Robin Collins, admits to Wisconsin police she hit Takoda. After receiving probation, Robin loses custody of him. On December the 9th, 2011, her probation is revoked and she is sent to prison. According to her, it was because of drug use. For several years, Takoda lived with three different foster families. Al Mutahal McLean, Takoda's biological father, was never around. He never called, he never even saw Takoda. McLean came for Takoda out of the blue one day. He went to Wisconsin and did a DNA test and he was Takoda's father. So Takoda is taken away from Anita Britson, who was Colin's friend, and took Takoda in to help Takoda's mother. Colin's fiancé was in the process of adopting Takoda, but after McLean took him away, they last saw him at his 4th birthday party. From 11 months old, from when he was abused, to the time they gave him to Al McLean, Brian, Anita's fiancé, was trying to get custody the whole time. Anita learned of Takoda's death the day after it was announced in December. On February 26, 2014, Robin Collins writes to the Wisconsin court that Al McLean moved with Takoda to Union City, Tennessee. On June the 30th, 2014, Al McLean files with the Wisconsin court his intent to move with Takoda to Pennsylvania. Takoda's mom signs a notarized letter agreeing to the move, then writes a handwritten letter days later saying she was bullied and pressured into signing the first letter. On August 18, 2014 is Takoda's first day of school at Horace Mann Elementary School in Dayton. Takoda's enrollment date is unknown, but school officials confirmed he was a student there starting in 2014. On October the 20th, 2014, Wisconsin court rules that Al McLean is allowed to move with Takoda to Pennsylvania. Robin Collins, Takoda's mom, maintains visitation rights. On 30th of December 2014, Amanda Heinze, Al's fiancée, buys a house on Kensington Drive in Dayton. On February 19, 2016, Montgomery County Children's Services calls Dayton police for a welfare check regarding possible abuse of Takoda's 9-year-old brother. No one answered the door when officers arrived. On May the 11th, 2018, Dayton Police Schools worker and Montgomery County Children's Services request a welfare check on Takoda because of fears he was being abused. Police respond to Kensington Drive house and get no answer at the door. Between the 12th of May and 24th of May 2018, Takoda is pulled from school by his father before the end of the school year, but the exact date is unknown, according to multiple Dayton school officials. School staff say they never saw the boy again. On 31st of July 2018, Takoda is formally withdrawn from school and is homeschooled. On November the 18th, 2018, Elle McLean and Amanda Heinze called Dayton police complaining Takoda is being unruly. Al asks police to take the boy to the Juvenile Justice Center. Once Takoda is in the back seat, his dad says he doesn't want to press charges and will take Takoda to Kettering Hospital. Hospital officials say he never went there. On May the 6th, 2019, Robin Collins, Takoda's biological mom, files motion for contempt in Wisconsin court against Elle McLean. McLean never took Takoda to see her. On May 13, 2019, Wisconsin court dismisses Robin's motion, saying the case is in the jurisdiction of Ohio since Takoda lives there now. On May 14, 2019, Robin calls Dayton police telling them she believes her son is being abused by McLean. Police respond and dispatch records say they believe Takoda was being cared for. Records don't say whether Children's Services was contacted. Al Mutahan McLean, Amanda Heinze and Jennifer Ebert's reign of terror over 10-year-old Takoda Collins ended on December 13 of 2019, when the torture inflicted by Elle, Takoda's father, was finally too much for this child to survive. Elle had inflicted injury to every part of Takoda's body. The abuse on Takoda's last day was unimaginable. Elle Mutahan McLean beat his child, stood on him pushing his full weight on the child's body, forced him into water as Takoda could be heard struggling, and in his final acts of humiliation, rage and torture, Elle repeatedly forced a broken chair leg deep into Takoda's rectum. Even more tragic than the facts surrounding Takoda's death were the facts of the life he endured in the House of Horrors that was 1934 Kensington. From as early as his first grade year in 2015, Takoda suffered daily excessive abuse inflicted by his biological father, Elle McLean, and encouraged and facilitated by his self-appointed stepmother Amanda Heinze and her sister Jennifer Ebert. When Elle McLean and Amanda Heinze withdrew Takoda from school in 2018 at age 9, they perfected his isolation from the world and unchecked could escalate their extreme abuse and torture. Although the extreme abuse existed while he was still in school, from the time of Takoda being withdrawn from school, his entire life was revolved around being locked in an empty attic, denied clothing, food, light, and access to the bathroom. Every single day and night of Takoda's life consisted of constant, unending torture. For entire days, 20 hours a day, he was forced to pose in bizarre and painful punishment positions. While Takoda suffered in his torture poses, these three idiots, including his own father, would monitor him from the comfort of their furnished living room or bedrooms. When Takoda dared move from the torture position chosen by his father, Elle McLean would horrifically beat him as punishment. If Elle McLean didn't notice Takoda moving, Amanda and Jennifer would alert Elle so that he could execute the punishment for the child's perceived disobedience. When Takoda, who had no other alternative, defecated in his filthy attic, Elle McLean became enraged and forced Takoda to eat his own feces, even as Takoda begged and struggled against him. Takoda then learned that this was expected of him and began to eat his own feces to avoid his dad force-feeding it to him. The crimes of Elle McLean, which were aided and supported by his fiancée and her sister, represent the worst kind of humans. He provided no mercy to his own son. On December 13, 2019, the nightmare of Takoda's life ended when Al McLean's severe beatings, water torture, and a brutal rape were finally too much for the 10-year-old child's body to withstand. Al, unable to revive Takoda for another round of torture, called 911. The call is disturbing. Rather than focusing on the current condition of his son, Al spends most of the call complaining about what terrible child Takoda was and how difficult he was to parent. At one point, when Al is instructed to give CPR, he can be heard retching and then complains it smells real rotten inside of his stomach. On arrival, paramedics found Al McLean waiting at the door. The child, Takoda Collins, battered and bruised from head to toe, was lying alone, unresponsive on the floor of the living room. Dayton Police Officer Evans also responded as paramedics attended to Takoda. Amanda and Jennifer were not there. To allow the medics to work without distraction, Officer Evans started talking to Al on the porch, during which Al still continued his rant about his uncivilized, uncontrollable child. His complaints to Officer Evans, which are repeated even in his formal interview, included claims that the child ate his own feces on the regular. Al also tried to explain away all the bruising on Takoda as self-inflicted dramatics of an uncontrollable child putting on a show. Although paramedics focused on attempts to resuscitate Takoda, the evidence of abuse was clearly present all over his body. At one point, paramedics indicate Takoda has passed. Al's response to the news of the death of his own child was, "Alright, I tried to get you guys here as fast as I could." Even still, medics continued to try to revive the child, including transporting him by ambulance to the hospital. Resuscitation was impossible, and Takoda, age 10, was pronounced deceased in the emergency department at Children's Hospital. Once at Children's Hospital, Dr. Liker, an expert in pediatrics specializing in abuse, had an opportunity to externally examine the deceased child. Takoda was battered from head to toe. Dr. Liker noticed hundreds of lacerations and abrasions to Takoda's head, face, mouth, neck, chest, abdomen, back buttocks, arms, hands, legs, and feet. The doctor also noticed extensive bruising to his entire body, including his scalp, face, inside of his mouth, neck, chest, abdomen, buttocks, arms, legs, and feet. Abrasions were found on his chest, abdomen, buttocks, and posterior legs. Older scars were seen on his torso and extremities. Injuries, lacerations, and bruising were also visible externally in the anal area. To Dr. Liker's expert eye, this extent and nature of the injuries were not consistent with accident or self-infliction. They were the result of severe physical abuse and torture on numerous occasions over a period of time. Many of the injuries were in areas that are very difficult to bruise. Many of the injuries were in defensive locations, the areas of the body such as the back of arms and posterior of the body exposed when someone tries to protect themselves from blows. There was also evidence of prior rib fractures that were not visible in the child's 2018 hospitalization for jumping out of the window. Poor kid, he was trying to escape his punishment and the torture, and I think that he jumped out the window to escape. In 2018, Takoda was evaluated by the hospital and referred for behavioral health therapy. However, the efforts by the hospital to connect Takoda with these services were rejected by the family. An Ohio judge sentenced Al-Mutahan McLean to serve the maximum allowable sentence, 51 years to life in prison, for torturing his 10-year-old son, Takoda Collins, to death in December 2019. The judge said the brutal facts surrounding the child's death amounted to the most horrific case of abuse and torture the court has ever seen. Montgomery County Prosecutor's Office Deputy Chief of the Criminal Division, Linda Dodd, said that the death penalty was not an option in McLean's case, but the sentence handed down was the next best thing, as McLean would be 83 years old by the time he would even be eligible for parole in the year 2072. If he ever is released from prison, Judge J. Dennis Adkins ordered him to register as a Tier 3 sex offender and a violent offender. Tier 3 is the category for the most heinous sex crimes in many states, meriting severe punishment and lifelong placement on the state sex offender registry for the sex offender. Amanda Heinze, Al's fiancé, was sentenced to a minimum of 22 years in prison. Her sister Jennifer Abbott was sentenced to 8 years in prison. This still blows my mind. On August the 20th of 2016, Takoda's 13-year-old brother ran away from the Dayton home. Once found, he told police that he was forced to do squats while holding a heavy backpack as punishment. Police contacted Children's Services and officers were told the referral was made. Police attempted to search the Kensington Drive address but couldn't access some parts because of pit bulls. Officers saw cameras inside and outside the house, but McLean told them the cameras don't record and were only present for show. Takoda attended Horace Mann Elementary School in Dayton, where teachers reported concerns about Takoda and his older brother to social services many times, starting around 2014 when Takoda was still in kindergarten. According to his teachers, Takoda often had poor hygiene and injuries, was too thin, and complained of starvation, beatings, and imprisonment by his father. In 2016, Takoda's brother ran away from home saying he was abused. And guys, basically this is everything that I could find out about Takoda's older brother. There's no public information what happened to him or where he is right now. So if you guys know any more details, please just put them down in the comments below. And if there's any new information, I'll just pin the comment to the top of the video. Dayton police school teachers say the father of Takoda Collins threatened school employees after they reported suspected abuse of the 10-year-old multiple times over several years before he died in December 2019. According to emails to state lawmakers from teachers at Horace Mann Elementary School, where Takoda attended from 2014 until his father, Al Mutahan McLean, removed him from DPS for homeschooling in 2018. The emails, obtained by the Dayton Daily News using Ohio Public Records law, ask for legislative changes to make it harder for someone accused of abuse to withdraw a child for homeschooling. They also express frustration that Takoda died despite numerous complaints to Montgomery County Children's Services. The Dayton Daily News is not naming the teachers for safety reasons because of allegations they were threatened for reporting abuse. I called more than once and soon learned that others had called too, wrote a second-grade teacher in January the 8th, 2020 email to State Senator Steve Huffman, a Republican whose Senate district includes Horace Mann. As a staff, we are trained to notice things such as bruises, marks, and signs of neglect, she wrote. For as many years as Takoda was at our school, we called. She specifically said there were reports from the nurse, several teachers, the principal, and police officers. Children's Services said they had no open case on Takoda when he died. She and another teacher at Horace Mann wrote that McLean became threatening after they contacted Children's Services. The father called and threatened our staff and our former principal. The other teacher wrote in a December 26th email to State Rep. Fred Strayhorn, D. Dayton. He must have gotten tired of calls and withdrew Takoda to homeschool him. Several Dayton area lawmakers have requested an independent review of how the case was handled by agencies such as Children's Services and Dayton Police, both of whom had received reports of abuse before Takoda died. Senator Huffman responded to the second-grade teacher's email. I can only imagine the pain, anger, and sadness you must be feeling as someone who knew and tried to protect him, Huffman wrote. You absolutely did the right thing by reporting any and all signs of abuse you suspected. I understand you like legislative action taken immediately to address the abuse and unspeakable terror suffered by Takoda and to prevent cases like this from happening in the future, Huffman wrote. I think it is important to allow county prosecutors and law enforcement to conduct their investigations so we know exactly what happened and what was or was not done to protect Takoda. You see, guys, but how can the teachers trust the system when they kept on reporting and nothing happened? And then you reach out to some politician or a senator or whatever and they still say that you need to let, authorities handle it. But let me tell you, this is not even the first time when Montgomery County Children's Services failed to protect children. And they messed up big time, big time. Montgomery County Children's Services placed a 4-year-old girl into a home with 2 known SA suspects and kept the child in the home after the girl and her 5-year-old brother said she was SA'd there. The report obtained by the Dayton Daily News says Dayton police launched their investigation when school staff alerted officers of the potential SA happening in the house. Dayton police say the investigation is ongoing, though the allegations extend back to 2018. Dayton police officers found Children's Services removed the sister and brother in November 2017 to get them out of a household where their mother was the victim of domestic violence. Children's Services placed the children with their grandfather, who had twice been charged with rape but not convicted, although he was convicted of domestic violence and the suspect in 2 other SA cases. Already living in the home was a teenager placed there by Children's Services because the teen SA'd a 5-year-old family member in another county. I can't fathom there would be any excuse for that, had said Holly Schleck, I'm hoping I'm pronouncing her name right, a former Hamilton County caseworker and published author on Ohio Children's Services issues on the decision to place children in that home. She said the allegations in the police report demonstrate a clear failure of the system and the need for more accountability and transparency for children's services agencies. The 4-year-old girl, which is unrelated to Takoda, told her mother that her grandfather was abusing her during a visitation in July 2018, shortly before the mother was to regain custody. The mother then told the caseworker about the allegation, but the caseworker allegedly didn't follow orders to schedule a forensic examination, left the girl in the home with the grandfather, and then continued court-mandated visitations between the grandfather and the children after the mother got the kids back. In response to questions from the Dayton Daily News, Montgomery County Children's Services officials said they conducted an internal review of the case but would not release the outcome of that review or comment on the case, saying agency records are confidential under state law. Staff records obtained by the Dayton Daily News show the caseworker received a letter of instruction in April 2019 for not adhering to the agency's mandated reporting policy in July 2018. As of 2020, she still remained employed at the agency. The letter of instruction says that if an agency employee is notified that a child is a victim or at risk of being a victim of abuse or neglect by a parent, guardian or custodian, the employee must immediately contact the agency's intake screening unit. They must then immediately fax over a report and notify a supervisor. No records of any other Children's Services employee being disciplined for how this case was handled were given to the Dayton Daily News in response to a public records request. The caseworker was hired in February 2016 according to her personnel file. Jane Hay, president of the union representing Montgomery County Children's Services caseworkers, wouldn't comment on the allegations except to say, "Our workers take pride in their work. They do the best they can within the constraints of the law and the agency guidelines. So I really find this hard to believe. The police report says Children's Services became involved in this case because of a domestic violence situation. The mother was a victim, and due to her children living in the home, safety precautions were put in place to keep the children safe from witnessing any violence with the adult male of the home. The report says, noting the mother was not accused of any violence toward the children. The report states the 4-year-old and her 5-year-old brother were placed in the home with their grandfather, who had a history of criminal complaints. The caseworker informed me that she placed the kids with a grandfather because the kids had gone to him before for babysitting and the mother wanted them to go to him originally. The caseworker said that she also spoke to the grandfather about his past, who told her that the past charges were just a date rape thing and that the victim was just mad he left her. I asked if the past police reports with the man's rapes were looked at by the caseworker, and she just looked at me without answering. This is from the detective investigating these allegations. Dayton police records obtained by the Dayton Daily News show the grandfather was accused in 2006 of offering a prostitute a ride home, then pulling into an alley on the way, saying he had a gun and raping her. Police were able to track him down because she remembered his vanity license plate. He was charged with rape, but the grand jury later declined to indict him and the case was dismissed, according to court records. In 2007, he was charged with rape, kidnapping, gross sexual imposition, and another SA charge. He was found not guilty by a jury. Also, in 2007, the grandfather was convicted of misdemeanor domestic violence after his 16-year-old son went to Children's Medical Center for stitches and said his father hit him. When the children were placed in the home in 2017, Dayton police records say the grandfather was named as a suspect in 2 additional SA cases that have since been closed with no charges filed. In 2011, his ex-girlfriend alleged he came to her house, forced his way in, and SA'd her. The case was closed after the alleged victim declined to follow through. In 2014, a woman reported that she was celebrating her birthday in downtown Dayton and had been drinking heavily when a man she didn't know pulled her into an SUV, assaulted her, and dropped her off in the Oregon district. A rape kit was conducted on the victim and found the grandfather's DNA. The investigation stayed open for years. The case was closed in 2018 without any charges filed. The teen living in the same house with the children was there because Children's Services considered it unsafe for him to continue living in another home with a 5-year-old family member he is accused of SAing in a different county. Even with the teenager having sexually assaulted another female child of similar age, the caseworker and even her supervisor signed off on the children being placed into the home with 2 SA suspects, the police report says. The police report also says a home study conducted before placing the children in the home didn't note the teen's past, though before such a placement, other juveniles in the home are supposed to be investigated using a statewide child welfare system that would have included that information. I was told this was a big red flag of the investigation, the police investigator wrote in the report. The detective wrote that an agency supervisor told him Children's Services would almost never place a child in the home of someone accused of rape unless their health assessment came back there is absolutely no way of the offender reoffending. But even then, they would be leery of placing the child in that home. County officials said that before a child is placed in a home, they complete multiple background checks. Their policy states they won't place a child in a home with someone with a felony conviction for spousal abuse or SA, or a misdemeanor offense within the prior year. It also says the agency should take into account whether criminal proceedings are pending against the person, though it's unclear if Children's Services knew about the open cases involving the grandfather when the children were placed there. The mother began getting visitation rights with the children in July 2018 and was supposed to get the kids back in August of 2018. During a July 2018 visit, the girl told her mother that her genitals hurt and that the grandfather had been touching her there. The mother said she checked her daughter and said that she was bleeding. Her son then entered the room and confirmed the allegations. The grandfather has not been charged in connection with abusing the child according to court documents. According to the police report, the mother sent the Children's Services employee an email on July the 25th telling her that the child had disclosed SA. The mother said in the email that the child was very detailed in talking about what happened, which concerned her, the report says. The mother said that she took the child to the doctor who said that the child did have irritation. The email also notes that she tried to call the Children's Services employee a day earlier and left her a voicemail. The report says the Children's Services employee's notes were reviewed and showed that she contacted her supervisor, then the doctor, and then the suspect before speaking with the mother and child. It should also be noted that the caseworker contacted the suspect of SA without contacting the police, potentially giving the suspect ample time to either destroy evidence or make up a false narrative, the police report says. The report also says the caseworker was also instructed by a supervisor to book an appointment with Care House, a center that assists abused children, for a forensic interview of the child that was not done. The report says it took the caseworker 6 days after the email to visit the children. While there, the child was too shy to speak to the caseworker about the SA, which is common for child SA victims based on my training and experience. However, the brother disclosed that he saw the grandfather touching the girl, the police report said. But the report says the caseworker still had the children continue to live with the grandfather. The police report also knows that no police report was filed at that time, and after the children moved back with their mother, they had to go back for scheduled visits with the man because it appears that the caseworker approved the scheduled visits with the court. That's when the school staff got involved. After the mother told the school therapist she was upset because she didn't want to get in trouble for not following the court-ordered visits, but she was concerned for her daughter's safety. When school staff called police, a criminal investigation was launched. The report doesn't give a time period for when the investigation started. The police report also says authorities spoke with the Children's Services caseworker about the many flaws to this investigation and as to why the children were kept in such a dangerous atmosphere. The caseworker said she had spoken with a family doctor who said that the mother never told her that the child was SA. The caseworker said she was notified that the child had skin irritation, but said the doctor was never notified about any SA. The report later says this was true. The doctor had not been told by the mother why she wanted her daughter checked. The caseworker said she tried numerous times to set up a forensic interview at the care house, but no one answered the phone and she was unable to leave a message. The investigator who wrote the report said the phone number had been called hundreds of times in the past and messages were able to be left. The caseworker didn't explain why she didn't keep trying to schedule a forensic interview or make a police report. The children were eventually interviewed at the care house after police became involved. The girl told investigators, according to the police report, that the grandfather touched her multiple times. The brother also disclosed that he saw the man touching his sister. Despite a very detailed disclosure by both children of alleged SA that took place on October 30th, 2018, by November 20th, 2018, the caseworker still had not filed anything with the courts attempting to prevent the court order visitations with the children and the grandfather. It was not until November 28, 2018 that anything was filed with the court to prevent the court order visitation with the grandfather. So 1 month later, 1 month later, law enforcement spoke to Assistant Prosecutor John Amaranti about a custody case involving the family, and the Assistant Prosecutor told police that the caseworker had told him that the children did not make a disclosure of SA during the care house forensic interview. I informed John that was highly inaccurate, and I got him a copy of the interview so he could witness it himself. After watching the interview, John informed me that what was disclosed in the interview was very different from how the caseworker has described it to him when preparing for court. The police report also says investigators reviewed an email sent by Children's Services employee to a co-worker where she claimed she interviewed the children and the girl would not corroborate what the mother was saying about SA. The caseworker further stated in the email that the older brother was obviously coached by mother as to what to say. It should be noted the mother informed me that before these allegations were disclosed, there was no problems between the mother and the grandfather. Furthermore, when the allegations came out, the mother was almost about to have her children fully back in her custody, so there really wasn't a clear reason as to why the mother would have made this allegation up. Furthermore, it is based on my opinion as well as the opinion of the forensic interviewer from training and the experience after conducting hundreds of forensic interviews that the children's disclosures appeared to be honest and too detailed to have been coached, especially for their age and intellectual capability. The police report obtained by the Dayton Daily News focused on the actions of Children's Services and whether a violation of endangering children or failure to report was committed. The status of the criminal investigation into the girl's assault is unclear. Neither Dayton Police nor the Montgomery County Prosecutor's Office will comment on the case. Mike DeWine ordered the review after 2 deaths of young children. In one case, Children's Services closed the case of a child born with marijuana in his system after 12 days. The child later died. In the Takoda Collins case, school employees and others say they reported suspected abuse multiple times before the child died. The failings of Montgomery Children's Services takes us to Takoda Collins estate settlement. Montgomery County has agreed to pay $3.25 million in a wrongful death lawsuit filed on behalf of the late Takoda Collins. The lawsuit was filed against Montgomery County Children's Services. It says the agency didn't do enough to help Takoda Collins after multiple reports of abuse from Dayton public schools teachers. Michael Wright is the attorney for the Collins estate. If they were not culpable in any manner, they would not pay $3.25 million to the estate of Takoda Collins. So I think that they are making changes that would help prevent this from happening to any other child, he said. Another lawsuit on behalf of Takoda Collins against Dayton Children's Hospital is still pending. Takoda's grandmother hired attorney David Brennan to help develop this lawsuit against Children's Services and possibly Dayton Police Department. So guys, let me get this right. The same grandmother who didn't do near enough to save Takoda then goes and hires a lawyer to file for wrongful death of Takoda Collins. Not only that, but the same grandmother who didn't do enough will take a portion of the settlement. Just the same as Robin Collins, the same mother that lost custody of Takoda because of her own fault. She gets a portion of the settlement as well. Maybe she will be able to get some more drugs. I don't know, just saying. Don't sue me. Usually, oh my god, these laws, it makes me laugh. Usually, Al McLean, being the father, would also get a portion. But at least we are lucky that because he was convicted of killing his own son, the judge or prosecutor or whoever stopped him from getting a portion of the settlement. Oof, aren't we lucky? And this is how much everyone is getting. The mother, she gets $50,000. The grandmother gets $100,000. The 14-year-old half-brother, the 11-year-old half-brother, and the 10-year-old half-sister get $572,450 each of them. Now, keep in mind, apart from the kids, obviously, Takoda's half-siblings, none of these people did enough to save Takoda, to protect Takoda, to help Takoda. He probably didn't even know his half-siblings. Where is the justice in this? He was left to die, tortured, terrified, alone, yet the family, again guys, I'm not saying about the kids, the half-siblings, but the rest of the family, they did nothing, absolutely nothing to save Takoda's life. Nothing at all. Yet, they get a settlement for a wrongful death. They get money. Oh my God. Takoda's aunt, McLean's sister, Zira Nichols, said his death came as a shock. She lives in Michigan and she said she spoke on the phone to her brother and Takoda's father, Al-Mutahan McLean, very often. You would have think everything was fine. He was like, you know, everything is good. They are going to school and everything is okay and they are outside playing and everything is okay, she said. Nichols also said McLean would often make up excuses though as to why she or her mother couldn't visit. To me, honestly guys, honestly, no offense, or get offended if you like, the aunt or her mother, Takoda's grandmother, who were they? Where were they? Where? Just because your son and brother makes up excuses as to why you can't visit, you just don't visit? At all? Never? You don't find anything off about it? Suspicious? Come on! I don't buy it. I just don't. If you are too comfortable to visit and you accept the excuse just because it gives you an excuse not to visit, that's a different story altogether. But don't blame it or point the finger at someone else. In the end, the case still remains that you just couldn't be bothered to do enough or to care enough. And no matter how many reasons you try to find so you don't blame yourself, the truth is nobody did enough. The family didn't do enough, social services certainly didn't do enough, the police didn't do enough. Nobody. If one of them had, Takoda Collins would still be here. One last point, guys, I want to touch before I'm ending the video, is about the 3-year-old toddler who was living in the house with McLean and Takoda Collins. I know you guys have been asking in the comments. I just want to clarify a few things because of the questions in the comments and the confusion about it. So Al McLean had a 3-year-old half-brother living with him, Josiah Nichols. This is McLean's half-brother, not Takoda's half-brother. Nichols said their mother, who lives in Tennessee, is in jail. According to Zira Nichols, who is McLean's sister, their mother lives in Tennessee. However, she is in jail, and so McLean took his 3-year-old half-brother to live with him. However, as far as I'm aware, Josiah, the baby boy, is now in custody of Montgomery County Children's Services. Former Montgomery County Sheriff and current state representative Phil Plummer tells the News Center 7 I-Team, which is essentially an investigative team, that he fears children in Ohio have been harmed because more than 5 months after passing the Ohio House bill, his child welfare reform plan is not yet a law. Plummer, a Republican from Butler Township, says the I-Team reporting system failures that played a role in the murder of 10-year-old Takoda Collins in December 2019 prompted him to introduce the legislation. As of October 2021, the I-Team's John Bedell continued his nearly 2 years of reporting on this case by pushing for answers about why the bill supporters say will prevent deaths like Takoda Collins has not been signed into law. News Center 7's search for answers started weeks ago, first calling Plummer in September, then asking him in person at the State House on October 12 why his bill requiring public agencies like those that failed to communicate in Takoda Collins' child welfare case to share information appeared to be stalled. I called the chairman of the Ohio Senate Judiciary Committee last week after we spoke, Plummer told the I-Team on October the 12th, and he says, "All right, I got it. I'll get on it and talk to the Senate president. They are good people in the Senate. They want to protect children, so we'll get it going." The I-Team checked, and Plummer's bill, known as House Bill 4, is currently in the Ohio Senate Judiciary Committee. Miami Valley State Senator Niraj Antani, Miamisburg, is a member of that committee. News Center 7 asked Antani for his reaction to Plummer, saying he's sure kids across Ohio have been harmed because the bill has not become law. "Well, I'm sure there are," Antani said. "What happened to Takoda Collins is a tragedy and an unfortunate situation." Antani said House Bill 4 had its second committee hearing at the end of October and added that traditionally a House bill needs a third hearing in a Senate committee before it can be voted to the Senate floor for a vote from the full chamber to send to the governor's desk for his signature to become law. In the Takoda Collins case, there was no go-to outside agency. So now, advocates are pushing for the creation of an ombudsman as a part of Plummer's bill to investigate cases like Takoda's and keep them from falling through the cracks. "I fear this bill doesn't go far enough, quite frankly," Antani said. "This bill is only effective if someone reports a complaint to the ombudsman. We know that while that may have happened with Takoda, that multiple complaints from teachers and others around the child file complaints, what we need is to hold children's services workers accountable. They fell down on the job in Montgomery County and need to be held accountable." Antani told the I-Team he does not think the bill goes far enough because he'd like to see children's services workers held accountable either criminally or civilly. Both of those things have either already been reviewed or have already happened in connection with the Takoda Collins case. In July 2020, Montgomery County prosecutor Matt Heck told the I-Team his office looked at everyone involved in Takoda Collins' welfare case and found nothing anyone did or did not do was criminal. "All I can tell you is that the Dayton Police Department investigators and detectives and my office looked at everyone who was involved in this case, went into the background of what happened, and looked at everything that was involved and everyone who was involved," Heck said in July last year. There were no other felony criminal charges available for anyone involved in this case. Heck then said last year it would be up to the Dayton Police Department to pursue any lesser misdemeanor charges through the Dayton City Prosecutor's Office. A Dayton police spokesperson told the I-Team in July 2020 that the department was not pursuing any misdemeanor criminal charges against anyone involved in Takoda Collins' child's welfare case. The I-Team asked both Plummer and Antani why House Bill 4 has taken so long to get to the governor. At the same time, both said children could be harmed without this law. Plummer and Antani both say the slow pace is part of the normal legislative process. Plummer told News Center 7 he'll keep pushing his colleagues in the Senate to meet his goal of passage by the end of the year. "I'm sure there's situations where we could protect more kids," Plummer said. "There is abuse that's going on every day. There is neglect that's going on every day. So we have to get this passed." WHIO asked Antani if Plummer's goal can be met by December. "Yeah, I think that's feasible," Antani said. The I-Team will continue to follow the progress of House Bill 4 at the State House in Columbus. Major Brian Jones said the police department is now mandating that officers complete a memo when they are called to do a welfare check in addition to contacting Montgomery County Children's Services. There also must be additional follow-up by police staff if the result of a welfare check is no answer at the door. I mean, I thought that this would be common sense, right? When you do a welfare check, you're meant to actually see the person that the welfare check is for. In my head, this kind of makes sense like this. When you do a welfare check, you are meant to see the person you are doing the welfare check for to make sure they are okay since welfare. But it seems that, common sense is not so common anymore. And honestly, it shouldn't have taken a child's life for a bill to be passed, for police to change their ways, and for social services to do more. But we see it time and time again. The system is just not working. The whole system is a failure. Thank you guys so much for watching today's video. I would like to ask you a huge favor. Please give this video a thumbs up. It will help spread the video on YouTube with the algorithm as well. The more people see, the more people will be aware, and the more YouTube pushes the video around. And also, I just want to tell you that now you can send any requests for any cases that you'd like me to cover through a form. So the link for the form is down in the description below. If you use that form, I'll make notes of the cases you want me to cover, and it will be, I think it's easier than trying to contact me on Facebook or YouTube or my email address. That way everything is there on the form and I can see everything clearly. Also, I would really like to focus my cases and my videos around cases which are not really covered in the media. I feel like we need to bring those to the public's attention as well. Again, guys, thank you so much for watching the video. Please take care and stay safe. Bye!